Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. We are going to talk about politics at work. Now, here's what's interesting. I talked about this a little bit before the presidential election, and it's very interesting because here we are now, a little over a month since President Trump took office. And there's a lot of discussion in the workplace about politics. Over the last few weeks, I've talked to you about executive orders relating to equal employment opportunity and DEI and immigration. And people are talking about these issues at work, obviously. So the first thing I want to do with you here this morning is just remind you of the legal protections we have in California for employees who engage in political activity, okay? We have lots of different protections, and I think for many of us, we don't focus on them because they don't come up all the time. But certainly with this last presidential election, we had an extraordinary amount of workplace debate about politics, and it has continued as the administration has formed up their appointees and issued so many executive orders and is really making the direction for the next 4 years clear from their perspective. So first thing I want to talk about is anti-discrimination provisions for employees. There are two sections of the California Labor Code that prohibit employers in this state from discriminating against employees for political purposes. We have California Labor Code Section 1101, which says that no employer can adopt any rule or regulation that forbids employees from engaging in politics. And they also can't control the political activities of their employees. The second Labor Code Section 1102 says that no employer can attempt to coerce or influence their employees to vote a certain way or to follow a particular political activity or party, okay? And both of these sections, 1101 and 1102, are intended to give California employees the right to engage in political activity without being interfered with by their employer. Interestingly, only employees who are fired for their political activities can sue under 1101 and 1102. Remember that political activity also is more broad than what we call partisan activity. So it's not just supporting a particular candidate or cause. It's also something that is related to just a political philosophy or approach, okay? Now, another provision we have in California law is Labor Code Section 98.6. This section prohibits employers from terminating or discriminating against employees for engaging in what we call lawful outside activity. So lawful activities that are outside of the employee's regular work hours, okay? And any employee who has been subject to that treatment, they've been discriminated against or retaliated against for those activities, they're entitled to reinstatement and lost wages and work benefits. There's all sorts of protections that come into play. There's another labor code section that's related, Labor Code Section 96K, where the employees can go to the labor commissioner and they can seek those lost wages for the demotion or the suspension or the termination from employment for that lawful outside activity. So very important to know that it's not necessarily a private right of action, but it's something where employees can go to the labor commissioner. Now, we also have a new law that I talked about several weeks ago when we were looking at the new laws for 2025, the captive audience ban that was enacted here in California. And there have been some similar developments federally with the National Labor Relations Board. The legislation here in California, which has now become law, bans employers from taking any adverse action against employees if they refuse to attend or participate in employer-sponsored meetings, or what they call captive audience meetings. regarding an employer's political or religious perspectives, okay? And political matters is very broadly defined to include things like elections for political office, political parties, legislation, regulations, or the decision to join or support any political party or political or labor organization. Union, in other words, okay? The California Labor Commissioner can enforce this law through what we call the citation process, where they can assess a penalty of $500 per employee for each violation. The employees can also bring a civil complaint. Now, several business groups have filed lawsuits to challenge the validity of the new law here in California, saying that it violates employers' First Amendment rights and that it's preempted, meaning displaced by the National Labor Relations Act. So we're going to have to see where that goes. We have a couple other rules here in California regarding political activity. First of all, you all know the California Elections Code requires you to give employees time off, up to 2 hours of paid time to vote. By the way, they get as much time off as they need to vote, but only 2 hours needs to be paid. You can require that it be taken at the beginning or the end of their shift. And you have to post a notice at least 10 days before any statewide election to let them know about those rights, okay? Similarly, employees who serve as election officers or who become candidates for elected office cannot be terminated or discharged because of their absence while they're serving as an election officer. They don't have to be paid, by the way, but you can't consider that like an unexcused absence. And you can't forbid any employee from running for office or accepting office. The election code also says that you can't use any force or influence to an employee's voting decisions. And that's a big deal. Under California law, such conduct is punishable as a felony by up to 3 years in the state prison system. So it's a big deal. We also have California's Ralph Civil Rights Act, which says that everybody in California has the right to be free from violence or intimidation based on their political affiliation. The California Civil Rights Act enforces that law, does so actually very aggressively to make sure that people do have the rights to express their political beliefs and affiliations. There's also something we have called the Bain Civil Rights Act, BANE, which forbids anyone from interfering with an individual's federal or state constitutional or statutory rights, including the right to vote and their freedom of speech. Okay, so we've got a lot of laws here. Now, what do we do in the workplace when employees have disputes about what's happening politically? And certainly right now we have a huge division in this country in terms of what's going on. One of our employees walked in today and said, well, my price of eggs hasn't gone down. I knew what they were talking about. I don't know if everybody did, but I had to tell her, hey, you know what? We just need to not make those comments in the workplace. You don't know how people voted. You don't know what people's views are. Because I'm a private sector employer, that employee doesn't have the right to make those statements under the First Amendment. There is no First Amendment right for them in a private sector workplace. Now, the California Constitution does have a free speech component, but private sector employers have the right to reinforce their core values and their standards of conduct. So if somebody wants to express their views or their political beliefs or affiliations, they have to do so in a respectful way. One of the things that I've noticed in working with clients on these issues related both to the presidential election and also to the Israel-Gaza war is it's very hard for people to talk about these issues civilly, and it's very hard for them to understand the other person's perspective. And I get that because these are very tough issues and they're issues that are near and dear to many people, and they really define who they are in many ways. So it may not be possible for you to say you can talk about these issues, just do so respectfully. It just may not be something that people are capable of doing. So you want to make sure that you are really clear about what your expectations are. I think sometimes we like to not be as direct and as transparent as we could be when we talk about these issues, because we don't want to offend people, or we don't want to, really take a stand. But, if somebody is being pretty outspoken in the workplace about their views, they very likely are making somebody else uncomfortable. So you're going to have to find a way to deal with that. Interestingly enough, even if your views are different. So you may have a manager who comes to you and says, I've got this, right-wing employee who's making all these inappropriate comments, or this woke, Democrat who's trying to convert everyone to see it his way. And taking a side, maybe they support the Republican, maybe they support the Democrat. Who knows? Who cares? The bottom line is we've got work to do, right? So when we're dealing with things like that are affecting productivity, you may have to sit down with everyone and say, look, you have a right to vote for whoever you want, to speak out on any issues you want, but at work, we need to focus on getting the work done. And that is much easier said than done. By the way, I've reviewed a lot of policies that have been written in this area that go too far, and that not only the National Labor Relations Board, but also the Equal Employment Opportunity Commission and the Civil Rights Department may have an issue with. So it's important to really think about, in your particular work environment, is political discourse a problem? Are you seeing some debates and discussions go a little too far? Do you need to provide some guidance in this area? And if you do, you're going to want to think carefully about how far you want to go and how you're going to explain what needs to be done from your perspective. Obviously, as HR leaders and as employment lawyers, we want to be fair. We want to be equitable. We don't want to take sides. You certainly can't, be an effective employment lawyer or HR professional if everything you say and the advice you give is colored by your own perspective, right? It just is never going to be effective that way. So you want to think about, number one, do you have an issue with this? If you don't, great, cross this off your list, okay? If you do think there may be an issue, and remember, you may not know, you may have to check around. There may be things going on out there that just haven't come to your attention yet. But if you do think there's an issue, then you want to sit down and think about things like your social media policy, your equal employment opportunity policies, your respectful workplace policies. And you've got to think about, how might they run afoul of the National Labor Relations Act? Okay, in terms of engaging in protected concerted activity, how might they run afoul of the Equal Employment Opportunity Commission regulations, the Civil Rights Department regulations, and the president's executive orders that we've been talking about? So we need to think about how to deal with these issues proactively and fairly so that we can focus on the main priority of the workplace, which is, of course, supporting our clients, our vendors, our patients, our customers, whoever they are. So I am not saying that this is easy. I'm not saying it's going to be a quick fix, but we definitely need to think about this, and not just during elections. These days, I think we're going to have more and more political discourse at work. So we're going to need to get a lot more clear internally what we want to do and how we can do it legally. So there's a few things to chew on for the morning. I'm so glad you joined me here today. I hope you have a wonderful rest of your day. Remember, if you have ideas or suggestions for me on the podcast, I'm all ears. Always happy to consider new topics and new speakers. If you can think of anybody you'd like to have as a guest on the podcast, let me know. Our support for the podcast just goes up every week. We have more and more people listening and commenting. So please let me know if there's something we can do to make it better. We really want this to be a useful resource for all of you. Thank you so much for spending the morning with me, everybody. Have a great rest of your day. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. post about it on social media, and or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.